Welcome, everybody, to episode 4 of the Law with Darren podcast. First and foremost, I want to thank you all for all the feedback and support I've been getting. Been getting a lot of good feedback from people, a lot of good questions. I will be answering them in a subsequent episode, okay? But today's episode we'll be covering the Massachusetts dog bite law, okay? So, getting right into it. First things first, as always, whenever you're covering a law, you should read the law. So, in this case, the law can be found in Massachusetts General Laws, Chapter 140, Section 155, and it states, here we go, ready? If any dog shall do any damage to either the body or property of any person, the owner or keeper, now key in on that, okay, the owner or keeper, or if the owner or keeper be a minor, the parent or guardian of such minor shall be liable for such damage, unless such damage shall have been occasioned to the body or property of a person who, at the time such damage was sustained, was committing a trespass or other tort, I'll cover what that means, or was teasing, tormenting, or abusing such dog. Okay? Then there's one last sentence. If a minor on whose behalf an action under this section is brought is under 7 years of age at the time the damage was done, it shall be presumed that such minor was not committing a trespass or other tort or teasing, tormenting, or abusing such dog, and the burden of proof thereof shall be upon the defendant in such action. Okay? So there's a lot going on here. But let's break the statute down piece by piece. This is what they teach you to do in law school, okay? So, it starts off with if any dog. So, right now we're talking about dogs, not cats, not iguanas, not parakeets, all right? So, if you have anything other than a dog that injures somebody, this statute will not help you. So, you have to look somewhere else, okay? Shall do any damage to either body or property of any person, okay? So, body, pretty clear cut, the human body. Property, interesting. So I guess if a dog comes and, bites a piece of artwork that you have as you're moving it, from one place to another, I guess that would fall within the statute. And then here's a word here. The owner or keeper, okay? Now, owner, pretty obvious what an owner is, right? Dogs, typically are registered. Ownership is pretty easy to prove, right? Unfortunately, dogs are property. So you can buy and sell a dog, okay? You can own the dog. You can be co-owners. The law in Mass is pretty open on that, pretty well settled. But here's the other word, though, keeper. What does keeper mean, okay? And why is it important? Well, Mass has covered the issue of what a keeper is in several cases over the last 30 years. I'll go through a couple of the big ones for you guys, all right, to see if you like them. To tell you exactly what the court found, okay? And here's another thing that is different from the Rhode Island statute on dog bites, which we covered in the last episode. So in Rhode Island, there was a distinction about whether or not the dog had bit somebody inside their enclosure or outside the dog's enclosure. And you can listen to that episode on YouTube, on the YouTube channel if you'd like. Whereas this statute makes no distinction to that. It literally says that if the dog does damage, the owner or keeper shall be liable for such damage. So it doesn't matter if the dog is in the dog's house, if the dog is inside the owner's house, the bite does not have to happen. If the dog bites and there's no proof that the plaintiff who got bit was tormenting, teasing, or committing some other bad act against the dog to cause the dog to lash out at them, you're liable. That's it. There's no requirement that the plaintiff prove that the defendant had knowledge that the dog was dangerous or had bitten people. Nope. Completely different statute than Rhode Island. This is what's known as a strict liability statute, end all be all, okay? So, I wanted to mention that. So, again, the issue here that really comes up because, again, there's no distinction about, where the dog bites, okay? The big fight with these mass cases are who is a keeper of the dog, right? Because if you're a keeper of the dog, you are just as liable as if you are the owner of a dog, okay? So one case I've found, which I think really does a good job kind of walking through the court's rationale, is the case of Brown versus Baldock. Those of you who want to read it, you can Google 29 Mass Appellate Court 909. This is a 1990 case. And in this case, it's very fact specific, so I'll kind of read it to you. Hopefully you don't get bored. But it's, again, these cases are very, very fact intensive, so it does help. So in that case, the court wrote, this is a dog bite case. Gail Brown, the victim, aged 32 at the time of the accident, brought her action against Sonia Baldock, age 29, and Sonia's parents, Jacqueline and Daniel Baldock. Upon trial, Gail, the plaintiff, had a verdict and judgment against Sonia on the basis of the dog bite statute. Okay? At the close of her case against the parents, the judge directed a verdict for the parents, and Gail filed an appeal. So basically, Gail was bit, and the dog is owned by a woman named Sonia, and Gail also sued Sonia's parents, okay? And the court directed a verdict in favor of the parents and let them out of the case, basically not finding that they could be found liable in this case. And then why did that happen? Let's go a little further. Here are the facts. On February 27, 1983, there was a luncheon party at Sonia's residence, a mobile home or trailer at 73 Dock Lane, Salisbury, Mass. Attending, well, it doesn't matter who. Sonia was there, her boyfriend was there, Gail's, the plaintiff's sister was there, a 4-year-old daughter. There were a lot of people there, okay? At around 1 o'clock, Gail, the plaintiff in this case, who was bit, walks into the trailer where they were having this party and got bit by a St. Bernard named Samson, who was a 125-pound dog. So this is a big boy, okay? The evidence was that Gail came in, greeted the dog, and the dog just bit her on the nose, okay? So there's no evidence that she tormented or teased or annoyed the dog or anything like that, all right? So the court wrote that the case against Sonia is very easy. So Sonia is the daughter, all right, who owns the dog, okay? There's again, if it's your dog and the dog bites, that's it, right? There's nothing else. Now, why was it important in this case for the plaintiff to keep the parents of Sonia, the dog owner, on the hook? Here's why. This is, as it always is, it's about insurance, okay? The plaintiff in this case, Gail, knows that Sonia probably has no money, not a dime to her name. You can't get blood from a stone, okay? But her parents, who own the land where Sonia, the daughter, is living, the trailer, most likely have homeowners insurance, which would cover the negligent acts of her parents. So, in this case, if the plaintiff can attach liability and keep the parents on the hook as the owners of the land, the homeowner's insurance is going to be on the hook too. So that's the deep pocket. That's the wallet that the plaintiff in this case really wants, okay? So the lower court, who tried the case, let the parents out, finding that under no circumstance could the parents be found as keepers of the dog, and basically didn't even let the jury decide whether or not the parents could be keepers, okay? But the court, in this case, the appellate court, found it a little differently. So what they noted was, and these are the facts from the case, they noted that the parents owned the trailer and related grounds, but lived at a distance of a mile or more from the place, from the trailer. Sonia, their daughter, resided with her boyfriend in the trailer rent-free, but paid all utility charges. While renovations were being made to a barn on the property, the parents kept 2 horses and a pony temporarily in the barn nearby. The dad, father, brought feed for the horses twice a week. The mom visited twice a day to groom the horses. The mom and dad would see the dog Samson as they passed. When he was kept outdoors, they would greet and sometimes pet him. The mother, on occasion, would fill the dog's water pail. Okay? So what the court found in this case was, and this they're holding more or less, is that all this advances, not at all, any claim that the parents or either of them were, quote, keepers of Samson. Okay? So, and then the court went on to say, it is difficult, of course, to frame a universal definition of keepership, but a, quote, harboring with an assumption of custody, management, and control of the dog, end quote, seems intrinsic to it. Okay? So, in this case, as you're kind of seeing here, the court found that there just weren't enough facts and evidence to overrule the judgment of the trial judge who actually tried the case, and find that the trial judge made a mistake in determining that there just weren't enough facts and evidence to even let the case against the parents go forward under the theory that the parents were keepers of the dog. Okay? So it's a very dramatic ending to a case that the judges have, when a plaintiff literally puts all their evidence in front of a jury, and then the defendant says, "Oh, Your Honor, there's just not enough here for a jury to even consider." And a lot of times, if the judge rules in the favor of the defendant, they can be overturned on appeal. So the judges are very careful to not make these kind of what's known as a directed verdict. But in this case, the trial judge who tried the case was upheld on appeal. So no issues here. Okay? So again, that's the case of Brown versus Baldock. The next case I want to go over is another case that dealt with the issue of what a keeper is. And this is the case of Perillo. Let me see here. Yes, okay. This case was heard with another case called Salisbury. So the citation's kind of weird, but for those of you who are interested to Google it, you can type in Salisbury versus Ferrioli, 49 Mass App Court 485. This is a 2000 decision. And this is an interesting case. So in this one, here's what happened. The plaintiff in Perillo, I apologize, was 73 years old at the time. I'm not sure whether that matters, but the court wrote it down. On October 9th, 1995, the plaintiff came from her house in Florida to visit her sister, Cameron, in Carver, Mass. Although the plaintiff had visited with the sister on other occasions, this was the first time the plaintiff slept overnight at her sister's house. The sister owned a terrier named Joshua, who stood about a foot high and weighed about 30 pounds. Cameron, the sister, and her son Mitchell, who lived with the sister, took care of the dog from day to day in all the usual ways. The dog was chained when outside the house. The local law called for a leash, and if free, the dog would run away as the house was not fenced. These are all facts from the case, by the way. I'm not making these up. When Cameron, the dog owner, and Mitchell, her son, were absent from the house, the dog was kept chained inside. On the morning of October 10, Cameron, who again is the sister, and Mitchell, the son, left for work. At about 8 or 9 o'clock, the plaintiff, again our 73-year-old plaintiff, arose and took coffee while still in a robe and slippers. She heard the dog whining to be let out and decided to take him outdoors to the porch to be chained there. She opened the back door. Then, facing the front of the house, with the dog facing the opposite direction toward the open back door, the plaintiff stooped and took the dog's collar in her right hand and held it. As she undid the chain with her other hand, the dog suddenly ran toward the door, pulling on the collar in the plaintiff's hand, and pulled the plaintiff over. She fell. She sustained severe injury to her right hip and suffered repeated operations to repair the damage. So, in this case, again, different from the Bolduc case, right? Because in this case, we have, a woman visiting her sister, right? So she doesn't live at the property. That's clear cut. And, of note, the dog didn't attack the plaintiff in Perillo. In this case, the dog injured her because the dog just bolted out of the house while she was trying to nicely let the dog out. But remember, the statute doesn't require a bite. The statute says if any dog shall do any damage to either the body or property of any person. So that is a very, very broad, definite term. Any damage. I mean, good God. It's kind of, interesting to see how far you could take this, any damage. Goodness. So in this case, dog clearly wasn't trained and dragged this plaintiff as she tried to let the dog out. Okay? So in Perillo, the court went on to say that, quote, in subsection A, there is no disagreement that if the plaintiff was the, quote, keeper of the dog. So again, the plaintiff is the sister who's visiting. Okay? There's no disagreement. If the plaintiff was a keeper, she could not maintain an action against the defendant. So she sued her sister, by the way. Now, again, people may say, oh my God, how could you do that? You're a real piece of garbage. You're suing your sister. She's suing her sister, but more than likely there's homeowners insurance, and they're the real, wallet in this case. So she doesn't want her sister's house. Again, I'm assuming, but I can tell you right now, this is really about the homeowners insurance, okay? So in this case, the case turned on whether the plaintiff was in fact a keeper. And in this case, the trial judge ruled that there was insufficient proof of non-keepership to go to the jury. And this was a mistake. So the lower court judge ruled that the plaintiff, that there was not enough evidence of non-keepership. So basically saying that, that the plaintiff in this case was a keeper, okay? And the appeals court didn't agree. They noted that, as a general rule, barring special situations, keepership involves, quote, harboring with an assumption of custody, management, and control of the dog, end quote. And then the court in Perillo went on to say, clear cut, the plaintiff's single casual act in the present case of holding a dog with a purpose to move it from one place to another does not easily fit within this general description of keepership and leaves, at most, an issue for decision by the trier. So by the jury, by the trier of fact. So the court found, the appeals court found that the lower trial court, who hears all the evidence, okay, appeals courts don't take evidence. That's all established before it even gets to them. They found that the judge made a mistake in basically agreeing with the defendant that the question of whether or not, by agreeing with the defendant that there was just simply not enough facts and evidence, not enough evidence for the question to be submitted to the jury about whether or not the sister who was visiting, the woman, the plaintiff who's visiting her sister was a keeper of the dog, okay? And that was a mistake. So the trial court should have let the question go to the jury. Now, the jury could have found that she was a keeper, but again, we'll never know because the trial court, the lower court, did not allow it to go forward. So that was a mistake, okay? And so now I want to move forward to another case, which is also connected to the Perillo decision. And this is the citation. It's really weird, but it's called the Salisbury case. This is another good case. All right. So this is one. So I'll kind of give you the basic facts, but so the plaintiff in Salisbury, and this is another 2000 case, was a veterinary technician, and she was bitten by a dog in her care. And she sued the dog's owner, a woman named Amy Smith, and a couple other defendants under the dog bite statute. Okay? And then here's what's interesting. So the vet tech sues the owners of the dog, and then the owners of the dog sue the animal hospital where the vet tech works. Now, why couldn't the vet tech just sue the animal hospital? Because of the workers' compensation statute, which doesn't allow you to sue your employer. There's a couple rare exceptions you have to prove, very hard to do. But when they created the workers' comp statute, which makes it very easy to get on benefits pretty quickly, in exchange for that, they basically took away the right for employees to sue their employers for negligence. Okay? So, anyways, the trial court in this case, the defendants moved for summary judgment on this case, and the lower court actually allowed summary judgment on the part of the defendants. Now, a summary judgment is basically when the plaintiff, it's when you ask the court to say, look, Your Honor, even if we believe everything the other side is saying, they can't win this case, and here's why. Okay? And it's it's another drastic remedy the court has to essentially end a case without it ever going to a jury. And it's not easy to win those, but occasionally the judges will grant them. And if the judge does, you can immediately take an appeal. Okay? So, in this situation, the court granted the summary judgment, and here's why. Basically, the court looked at the facts of this veterinary tech who, while working at a veterinary hospital, was bit by a dog at the veterinary hospital, and essentially found that at the time of the bite, that this vet tech could be found as a keeper of the dog. Okay? And the court even goes on to state that, quote, the statute is rendered meaningless if one who in the course of their employment exercises control over and provides care for a dog is not found to be that dog's keeper. So again, if you work at an animal hospital and you get bit by a dog, while again within the course of your employment, you are that dog's keeper at that time. So when someone brings their dog to the animal hospital for veterinary help, right, and the owner leaves, and it's your job to handle these dogs, and you get bit by that dog, you can't recover under the theory that because you yourself are the keeper of the dog. Okay, so keepers and owners can't sue themselves, right? The owners can't sue themselves, and the keepers can't sue themselves. Okay, because you're responsible for the dog that you are in charge of keeping. Okay, so that was an interesting case, which I thought was really good to go over because it covers what happens when you bring your dog to like a veterinary hospital. Now, here's the interesting part. Let's say the dog, rather than bite an employee of the vet clinic, gets loose and bites a customer in the parking lot, right, of the veterinary hospital. Well, under this theory, the court could find that the veterinary hospital, again, consistent with the Salisbury case, was the keeper of the dog, and therefore the veterinary hospital will be just as liable if that same dog, snuck out and bit another patron of the veterinary clinic, in the parking lot. Okay, so this is actually a very interesting case, as I think it really establishes puts a lot of liability on veterinary clinics for this very reason. Okay, so another case I want to cover for you guys. Let me see here. Another good one. The case of Reed versus Phillips. Okay, so this is a cool case. So we've gone over situations where, it's like who owns the dog. Well, sorry, if the dog happens to be on your property, the court's finding clear cut that the dog, the people are not keepers of the dog. But it doesn't really tell us, circumstances that we can look to in cases where the court does find that they are a keeper, right? So we know what doesn't qualify, but let's get an example of what does qualify, right? What set of facts would we need to see for the mass appellate courts to say, that they're definitely a keeper, or there's definitely enough here, Okay, so that case is the case of Reed versus Phillips, 2003, Mass Appellate Division, 157. So this is another cool case. It's short, but in this case, the plaintiff. I'm sorry. In this case, so the dog is owned by a guy named Phillips. Okay, and Phillips has a girlfriend named Patricia, and they all live together with a dog. It's an American Bulldog named Dixie. So you got Phillips, and then his girlfriend Patricia, and they own a dog named Dixie. Dixie was purchased by the girlfriend 11 years prior to trial. She registered the dog, herself as the owner 10 days after the bite. Okay? And here's what's interesting. Here's why this matters. Reed, the plaintiff in this case, the person who was bit, was at Phillips' home. So Phillips, the boyfriend, owns the house. So the plaintiff needs to keep the owner of the house in this lawsuit at all costs. You have to. Because if the owner of the house is out, then you have to go after the girlfriend, and the girlfriend's not going to have any money. You can't get blood from a stone, so you get a judgment against this girlfriend, and good luck trying to get her money. It's really not going to be worth it. So the plaintiff needs to keep this guy Phillips, the boyfriend, in the case. Okay, the case went to trial. Plaintiff was found to have damages of $40,000. Okay, and in this case, the defendant appealed, trying to find that, Your Honor, there's just not enough. There was never enough evidence in this case to show that the owner of the home was a, quote, keeper, as, mass courts have decided. But in this case, the court found differently and actually ended up upholding the decision of the lower court. Okay, so here's what happened. So what the court noted was that Phillips, the boyfriend, maintained that the dog belonged exclusively to his girlfriend. Okay, but the court found, as it may, that Phillips, the boyfriend's version of that fact was not credible. The court looked elsewhere for evidence on the issue of keepership and found it in the testimony of McDuffie, the girlfriend, who begrudgingly admitted that the boyfriend sometimes walked the dog, fed it, and was alone with it on many occasions. Even the boyfriend was even forced to admit that he sometimes fed the dog by throwing it scraps. And while it is not dispositive, dispositive means end all be all, right? So the ultimate determining factor of the issue of keepership, it is worth observing that the dog resided on the same premises as Phillips, the boyfriend, for 10 years. Okay? So, and the court goes on to remind everybody that there is no litmus test for determining when a person is deemed to be a keeper under the statute. Okay? But the court does go on to say that usually that issue as to whether or not someone is a keeper is a decision that should be left up to the finder of fact, who would be the jury or the judge if there's no jury, if you waive having the jury in your case. Okay? So, in this case, the appeals court looked and did not agree with the defendant and said, yeah, no, there's enough evidence here. We are not going to disturb the judgment of the trial court and overturn their decision. Okay? And basically, so this is again a very fact specific case where the appeals court looked and said, nope, there is enough evidence here to show that the owner of the home, this Phillips guy, could have been found to be a keeper of the dog, and therefore good news for the plaintiff, because now with this Phillips guy, the boyfriend, on the hook, that means that his homeowner's insurance will also be on the hook as well. Okay, so we've covered what is a keeper, because again the issue of it's pretty easy to establish what an owner is, right? You either own the dog or you don't, or it's a stray, but no one's going to argue. If you want the dog, back, you're not going to say it's a stray. It probably has a collar with your address on it or your name. So good luck with that argument. But again, what is a keeper? A lot of cases, a lot of different decisions, a lot of guidance, okay, on this one. Feel free to go back and listen to any of the explanations I gave. Oh, and I want to cover one last case, actually. Because, if you remember, you're liable for your dog if your dog bites, unless, at the time of the bite, the person who was bit was committing a trespass or other tort being like a battery, like an assault, right? Anything like that. Or was teasing, tormenting, or abusing such dogs. So I did find a case that shed a little bit of light on, what it means to tease a dog. And this is the case. It's a very short one. 1991 case, Burgoyne versus Owen. 1991 Mass Appellate Division, 192. And in this case, clear cut. What happens is the plaintiff, so this happened over in Falmouth, the plaintiff and the defendant and their two dogs, a dog named Fritz, who was owned by the defendants, and Maxfield, who was owned by the plaintiff. Fritz, the larger dog, so the larger defendant dog, broke out of the house and attacked Maxfield, who was on the deck. While other adults and children stood by, plaintiff and defendants rushed in to break up the fight. During this time, the plaintiff kicked Fritz, so Fritz is owned by the defendants, 2 or 3 times, and Fritz then, after being kicked, bit the plaintiff in the left calf, causing a jagged hole. So this is a dog fight, right? So the plaintiff's trying to break up a dog fight. So the plaintiff sues the defendant for saying, hey, your dog bit me. But the defendant says, wait, not so fast. You were tormenting and teasing and assaulting the dog. You're kicking a dog. What do you expect? So the court in this Burgoyne case, thankfully, made the right decision and found basically that the kick in this case was intimately associated with efforts to terminate a dog fight. No other facts intervened to suggest that the kicks were associated with any pre-existing ill will on the part of plaintiff towards Fritz. That leaves the kicks in the context of efforts to terminate a dog fight as the basis for determining if plaintiff's acts were intended to irritate the dog or were designed to prevent Fritz from causing further harm. So in this case, the court found that, kicking the dog, even though it's technically an assault, right? Obviously, I think that would qualify as teasing or tormenting. The purpose of the kicks was not to tease or torment, but to stop a dog fight in progress, and from allowing the offending dog to continue to inflict more harm. So in that case, the court upheld the decision of the lower court and found, and did not buy the argument of the defendant that they can't be found liable because even though the dog bit, it was being tormented or teased or anything else. All right, so that covers the decisions, guys. I hope you guys enjoyed it. I will try to post the citations. If you guys have any questions, please email me. Okay, I'm happy to do like a follow-up episode, answer any questions. You can also comment on Facebook. The Facebook group is live. A lot of people are joining. Very happy to see that. Hope you guys learned something today. If you have any questions, again, email me, lawwithdarren@gmail.com. I'm licensed in Rhode Island, Mass, Connecticut. The next the next series of laws that I'll cover is the Connecticut dog bite statute, which is a little different than both Rhode Island and Mass. I've had a blast with this, guys. On the YouTube page, please like and comment, and subscribe. And take care of yourselves. Be careful if you have a dog on your property, and be careful because if that dog bites, you don't want to be found to be a keeper of that dog. So hopefully now you can take steps based upon what I've told you to try to prevent a court from determining that you are in fact the keeper of a dog. Have a great day, everybody, and take care.